Part three is the final part to our lecture series in Module 2. Part three is defenses to crimes. Prosecutors must prove beyond a reasonable doubt the five elements of criminal culpability and that they have been met. A defendant can raise a defense, which is any set of identifiable conditions or circumstances which may prevent a conviction for an offense. It can be failure of proof. This is when the prosecution fails to prove the cause of action. This is when a motion of acquittal following presentation of the prosecution's case occurs. The defendant introduces evidence that the prosecution's case doesn't provide sufficient basis for conviction. There's a statement of reason for invalid cases, whether it be true or affirmative in that type of defense. In terms of burden of proof, beyond a reasonable doubt is the burden of proof in a criminal case, and that burden rests with the prosecution. A failure of proof defense indicates that the prosecution must introduce evidence of the defendant's guilt and disprove the failure of proof defense beyond a reasonable doubt. Under a true defense, some statutes require the defense to introduce evidence of the claimed defense and convince the jury by a preponderance of the evidence, which is the same burden of proof in a civil trial. If that burden is met, the prosecutor must prove the defense beyond a reasonable doubt. And then finally, an affirmative defense. The defendant admits existence of the elements of criminal liability, but offers one or more legally recognized defenses. You have mitigating defenses, which reduces the level of the offense the defendant may be legally convicted. For example, a defendant convicted of murder may have that reduced to manslaughter due to extreme emotional distress. A complete defense, if it's established by the defense, it results in a full acquittal of the defendant. Justification is a type of true defense. It renders lawful conduct that would otherwise be a violation of criminal law and exempts the perpetrator of that act from criminal sanction. An excuse is when a perpetrator has violated a criminal statute, but there is a reason for not holding him or her personally accountable. This frees the perpetrator from criminal responsibility for his or her own actions. There are five types of defenses based upon justification. The first is self-defense. This is the justified use of reasonable force by a non-aggressor when the defendant reasonably believed the force was necessary to defend himself or herself from an unlawful and imminent attack. Self-defense is the most common of the affirmative defenses, especially in homicide cases. It's recognized in every jurisdiction in American criminal law. But there are three elements the defendant must prove: that there was a necessity of using the force, including any deadly force, the proportionality of the force to the threat. The force can exceed compared to the force threatened. And then finally, reasonableness of the belief the force was necessary. Aggressor is one who employs hostile force first through threat of attack or actual attack. This may generally not raise a self-defense claim unless the aggressor, the non-deadly aggressor, is met with deadly force, or the aggressor completely withdraws from a continued conflict. Deadly force is defined as force that is likely or intended to result in death or great bodily injury. But there is a no retreat rule. A non-aggressor may use deadly force when faced with deadly force, even if the opportunity to escape exists. The second major type of defense based upon justification is the defense of others. This particular type of defense has evolved considerably within the law. A person is justified in using reasonable force to defend someone when that person reasonably believes that the other person is in imminent danger of bodily harm from an unlawful aggressor, and that using force is necessary to avoid harm. Issues include determining the category of persons who can be assisted, and identifying the situations when the person being defended had a legal right to self-defense. According to the Model Penal Code, 3 conditions have to be met. The actor must use force as he or she believes would be entitled for them to use in self-defense, based on the circumstances he or she believes them to be. Under the circumstances as the actor believes them to be, the victim must be legally justified themselves in using the same level of force. And the actor must believe his or her action is necessary for the protection of the victim. The third type of defense based on justification is the defense of property and habitation. A person is justified in the use of force to protect his or her property from encroachment. For the use of deadly force, the threat must be against the person's residence, and the owner believes the intruder intends to injure the occupants, and deadly force is necessary to repel the intruder. Some jurisdictions require a reasonable belief that the intruder intends to commit a forcible felony or kill or seriously injure an occupant, and deadly force is necessary to repel the intruder. Reasonable force, but not deadly force, is justified to defend property from trespass or theft when the owner of the property believes the property is in imminent danger of unlawful interference and force is necessary to stop that interference. Keep in mind that the amount of force has to be proportional to what is needed to protect the property. If property can be protected without force, the owner must do so. Under the Model Penal Code, 3 conditions exist for this type of defense. The other must be unlawful. The owner must have possession of the property or acting on behalf of someone in possession of the property. And the force must be immediately necessary, or there is no rightful claim by the intruder. The fourth type of defense is the defense related to crime prevention and law enforcement. This category of defense authorizes law enforcement to use force in certain circumstances, which include to stop and arrest someone who is committing or who has committed a crime, to prevent an escape from custody by someone subject to arrest or who has been arrested, to prevent the commission of a crime, to suppress riots and disorders. But when using force, officers must act reasonably with the appropriate degree of force and not deprive an individual of their constitutional rights. When met with any type of resistance during a lawful arrest, an officer may reasonably believe force is the only way to stop a suspect from harming the officer or others. But there are rigorous requirements for officers to use deadly force in the Model Penal Code. When there's a substantial risk that the subject will cause death or serious bodily injury to another, and the use of deadly force does not present substantial risk to bystanders. As a reference, a landmark use of deadly force case is Tennessee versus Garner in 1985. The fifth major type of defense based on justification is necessity, or what's known as the choice of evils. This is when the actor chooses the lesser of 2 choices of action, but both will cause harm. In the common law, 6 elements of necessity are when the actor is faced with clear and imminent danger, the actor must expect as a reasonable person that his or her action will be effective in stopping the danger. The actor may not claim the defense if there is an effective legal alternative available. And the harm caused must be less than the harm avoided. The legislator must not have decided the balancing of the choice and legislated against it. And the actor must not have wrongfully placed himself or herself in the situation that requires the choice of evils. And there are 3 additional limitations. Some states limit the defense to situations created by natural forces. The defense may not apply to homicide cases, and a person may not merely act to protect his or her reputation or economic interests. Consent is not normally a defense in criminal cases because crimes are considered, remember, to be against society and not an individual. When victims agree to the actor's conduct, consent defense may not be used when it negates an element of the offense or prevents the harm addressed by the law defining the offense. Under the Model Penal Code, consent is a defense if such consent negates an element of the offense or precludes the infliction of harm or evil sought to be prevented by the law defining such an offense. The defense is not valid if the victim is legally incompetent to authorize consent. The person is unable to make a reasonable judgment, or consent is by force, duress, or deception. There are five major legal defenses based upon excuses. Even though an actor's conduct was criminal, he or she is not legally culpable under an excuse defense. The first being age or infancy. Under the common law, a person under 7 is conclusively incapable of forming an evil state of mind, which means they lack mens rea. From the ages of 7 to 14, the prosecutor could introduce evidence that the defendant recognized the difference between right and wrong, and over 14 is considered criminally responsible. The current trend is to reduce rather than increase the age at which children can be held criminally responsible, and state statutes vary in this matter. The second legal excuse is duress. A person committing an unlawful act due to threat of imminent death or serious bodily injury to themselves or another may assert the defense. Duress can be used in the following circumstances: when another person threatens to kill or seriously injure the actor or another person unless the actor commits the crime, the actor reasonably believes that the threat is real, and the threat must be immediate or imminent at the time the actor commits the crime. There must be no reasonable means of escape or avoidance of the threat other than to commit the crime, and the actor must not be at fault in exposing himself or herself to the threat. The third legal excuse is intoxication, and this is part of the Model Penal Code. Intoxication is a disturbance of mental or physical capacities resulting from the introduction of substances into the body, any substance that causes distortion of the senses. This takes the form of a failure of proof claim. For example, the mens rea element of the crime was lacking, or the act was not voluntary. Voluntary intoxication is the willful act of introducing these substances into the body that a person knows or should know that they are likely to have intoxicating effects. As long as the defendant is the one responsible for getting intoxicated, he or she has acted voluntarily. Therefore, the intoxication defense can usually not be raised. The defense of voluntary intoxication can never be used in a general intent crime defense. Voluntary ingestion is the mens rea required. The defense is valid for specific intent crimes. If due to intoxication, the person was incapable of forming the specific intent to commit the crime, they can raise the defense, but they must be highly intoxicated. Involuntary intoxication means the person is coerced, or intoxication by duress or coercion. They're pathologically intoxicated, meaning they're grossly, excessively intoxicated, to which the actor does not know he or she is susceptible to committing a crime. A person could be involuntarily intoxicated by mistake, innocent mistake. The actor is mistaken about what the substance is or tricked by another to take it. And then unexpected involuntary intoxication from ingestion of prescribed drugs. The Model Penal Code identifies the types of involuntary intoxication as self-induced, pathological, and involuntary. The fourth legal excuse is insanity. A person suffering from mental disease at the time of the crime may be relieved of criminal responsibility. When asserted successfully, it doesn't necessarily lead to the freedom of the accused. They're often committed to a mental hospital. The person must be mentally competent to stand trial in the first place. Incompetency is a person's inability to consult rationally with an attorney or to understand the nature of the proceedings against him or her. This type of defense may be raised by the prosecution or the defense in a case. In terms of insanity, what will lead to a bifurcated trial is a criminal trial that's divided into two parts when the insanity defense is raised. The jury decides not guilty, and the person is acquitted and the proceedings are over. Another way is a jury can decide that a person is guilty. The judge or jury holds a separate trial to determine if an additional verdict of not guilty by reason of insanity is required. In this bifurcated trial, trial evidence is only regarding defendant's mental health. Bifurcated trials are also used in death penalty cases. There are 4 tests to determine sanity of the only if his or her mental disorder made him or her unable to determine the nature of the act or the fact that it was wrong. The McNaughton test is used in many jurisdictions in the United States. When the defendant does not know the nature of the act he or she is committing, this is interpreted to mean the defendant does not know the difference between right and wrong, or doesn't understand the consequences of the act committed. Delusion could also be applied to the test. For example, the person understands the nature of the act, but does not know right from wrong. The irresistible impulse test is when the accused had a mental disease that kept him or her from controlling his or her conduct. The defendant may have acted as a result of uncontrollable impulse, lost the power to choose between right and wrong and to avoid the act, or did not have the will necessary to control his or her actions. The diminished capacity excuse may be raised when the accused was suffering from mental condition insufficient to support an insanity defense under the applicable test to determine whether they had the mental state required for conviction of the crime. The diminished capacity defense can be used in 2 circumstances: a failure of proof defense in which the accused raises the condition to negate the mens rea element of the crime, and a true partial defense to mitigate one charge to another, for example, reducing murder to manslaughter. Other legal excuses include mistake, which is when the defendant acts without an evil state of mind because his or her belief as to whether the facts of the law were applicable to a particular situation. This is definition in the statute and may make an inaccurate interpretation whether conduct was prohibited. Another legal excuse is entrapment. The defendant is tricked or otherwise induced by law enforcement to commit an illegal act that he or she would not have otherwise committed. And then the statute of limitations, also diplomatic immunity and the defendant's incompetence to stand trial.